Greetings and welcome to Oath and Affirmation from American Jurisprudence. Before we get started, please hit the like if you haven't already. And this presentation will be strictly for the educational entertainment purposes of this YouTube channel, not to be used misconstrued or mispurposed for anything personal, private, lawful, legal, business, tax, financial, or otherwise, so please don't do this at home. And from that, let's begin with the presentation here of Oath and Affirmation. Let's make sure we're all zoomed in properly here. Okay, so we're going to start out with, this is a very short chapter of American Jurisprudence, so I figured it would be best just to put it into a nice presentation here so we could get the salient points right up front. And for further research, you can always refer to American Jurisprudence for more, where it has the references to where all this comes from. But this is essentially all the parts in each of the sections. So let's get started with Section 1, the oath. What is an oath? In general, an oath, it's a solemn promise to tell the truth. And it has binding the conscience in a way that's not tied to specific words, but it signifies that the person making that statement is going to do it faithfully. So the oath is a formal declaration made under appeal to God. It signifies a binding conscience to act faithfully. It's subject to perjury prosecution if fabricated, and the acknowledgement of obligation sufficient where no particular words required. So what we're doing here with the oath, it's not necessarily the particular words, but it is a formal declaration, and it's made under appeal not only to God, but it's subject to perjury of prosecution, to the penalties. So it's basically saying that you're agreeing to taking whatever penalties there were to be established if you're not telling the truth. So help you God is not essential. A written statement with penalty for false statement equivalent to sworn statement. So there's different ways you can use this oath. Although it is to be under appeal to God, it is not essential. The written statement with a penalty, again, you're willing to pay the penalty for a false statement. It's the equivalent to a sworn statement. On to Section 2, an affirmation. So we went to oath, which is that declaration made under appeal to God. The affirmation is a declaration of truth, written or oral. It's also a solemn undertaking to tell the truth. But an affirmation does not invoke the deity. So the oath involves calling on God to witness truth. The affirmation, for those with conscientious scruples against taking oaths. So the affirmation is equivalent to an oath, but without invoking God. And it's used for those with scruples against oaths. All right, we're on to Section 3, the affidavit. The affidavit is a voluntary declaration of facts written down. It is sworn by the declarant, also known as the affiant, and before an officer that's authorized to administer oaths. So the officer is authorized to administer oaths. It's sworn before that officer. An affidavit is a written statement of facts confirmed by oath or affirmation taken before a person having authority to administer such oath. The example given here is a notary public. So the affidavit are the written facts sworn before an authorized officer. And we're on to Section 4, the acknowledgement. Let's jump over here to chat to make sure that we're all caught up with that, and it looks like we are. Indeed, please hit the like if you have arrived. The acknowledgement is an act of a person who has executed an instrument. So now we're talking about, typically here, a written instrument. And that would require the acknowledgement, because that's the act who has executed the instrument, the act of the person, going before a competent officer again, and declaring it to be his or her act or deed. So when an instrument is being executed, there's an act of a person, it's declared to be his or her act or deed. A formal declaration before an authorized officer that execution is his or her free act and deed. So the acknowledgement is that formal declaration. That the signed document is the signer's act. Pretty simple there. We're on to Section 5, to bind conscience. Now, this is not merely a technicality, to bind the conscience, because anyone can say words, but how are we binding it to the moral duty to tell the truth? This is the highest test of truth, and is to impress a sense of obligation. It binds the conscience when rights are affected. So the purpose of the oath or affirmation is to impress the legal and moral duty to tell the truth. So we have here the function, bind conscience of speaker, ensuring recognition of legal obligation to tell the truth. So that's the purpose of to bind the conscience with the oath, affirmation, affidavit, and acknowledgments. Section 6, to permit prosecution for perjury. This makes a person amenable to prosecution, or amenable to prosecution for perjury. The key to valid oath, perjury will lie for its falsity. So there's a penalty if you lie. The penalty will lie for the liar. Essential that the statement be given under oath, actually administered. So the statement that is given must be given under an oath that was actually administered. An oath not authorized by law is extrajudicial and of no binding force. So the administering of an oath serves not only to bind the conscience, but to create legal accountability for false statements. So we're binding the conscience, the appeal to a deity or to higher purpose or whatever it may be, but there's legal accountability for the false statements too. So this is to permit the prosecution. This is the other side. We want to first bind the conscience on the good faith, but there need to be legal accountability for the false statements. So oath makes false statements punishable as perjury, and unauthorized oaths are invalid or void. Section 7. Generally, this is the capacity to take oath or affirmation. Every person of sufficient understanding is capable, unless disqualified by statute or common law. The capacity to take the oath, turns on understanding of duty and consequences. So the taking of the oath or affirmation turns on the understanding of duty, understanding of the duty to tell the truth, and the consequences of falsehood under oath. So anyone of sufficient understanding can take an oath or affirmation. We're on to Section 8, the necessity of religious belief. Belief in God is not essential to validity of the oath. The absence of religious belief does not disqualify a person, and the statutory or constitutional provisions permit affirmation in lieu of oath. So depending on your state, the statutory or constitutional provisions permit affirmation in lieu of oath, although the legal system accommodates all individuals regardless of religious belief through the affirmation option. So in different states, there'll be different options, but there should be some option regardless of religious belief to permit an affirmation in lieu of an oath. And that's the belief in God is not required. The affirmation suffices without religion. And we're on to Section 9. Taking of oath by representative. The oath must be taken by the person whose act or testimony is to be verified. It cannot ordinarily be taken by an agent or representative. It must be taken by that person. Where law requires a particular person to be sworn, another cannot substitute. Personal obligation requires personal verification. Oaths cannot be delegated. The oath must be taken personally, not by proxy. And we're on to Section 10, the authority to administer. Authority of judges to administer oaths is not inherent. It exists by virtue of constitutional or statutory provision. So there must be a constitutional or a statutory provision that authorizes a judge to administer oaths or affirmations. Courts and judicial officers may administer oaths within prescribed scope. So the judicial authority to administer oaths derives from legal authorization, not from the position itself. So just because they're a judge or so doesn't mean they have the authority to administer oaths, although they may. But that would come from legal authorization, not from the position itself. Very fine distinction that the judge's power to administer oaths comes from law, not inherent authority. And we're on to Section 11. So, of course, the question is, by what authority are you administering this oath? And it can't just be because you're a judge. So we're on to Section 11. Persons interested may administer. Authorized officer not disqualified by reason of interest, unless statute provides otherwise. Disqualification arises only where law declares or impartiality is compromised. So, the persons interested may administer, unless there's some of these disqualification where the law declares or impartiality. Again, you got to consider that if there is some type of bias implicit with who's administering the oath, that could taint the validity of that oath or affirmation or affidavit, etc. The authorized officer not disqualified by reason of interest may administer, though. So interest alone does not automatically disqualify an authorized officer from administering oaths. But if there is something in there where they'd be disqualified either because of their personal interest or reason of interest, or where the law declares, then they may not. But just because they have an interest in it doesn't necessarily disqualify them. There has to be a reason of interest or a disqualification where the law declares. Or you can, argue the impartiality is compromised, which is most cases. That's why usually the person's interested, they may administer, but it's best they don't. So, on Section 12, the disqualification of attorney to administer oath for client. Attorney, not per se disqualified to administer oaths unless a statute or rules specifically prohibits it. It is improper or prohibited in many jurisdictions, though, because the conflict of interest concerns may prevent attorneys from administering oaths to their own clients. So the attorneys generally should not administer oaths to their own clients in related manners for obvious reasons. I'll check over here to the chat as we're reaching about the halfway point here. No Bible necessary for testimony. Well, we haven't got to that yet, Bill Thomas. Please don't step ahead of the presentation here. Yes, you have rights. This is definitely some important stuff and foundational that we're supposed to know these fine distinctions here because they function in our everyday lives, whether we're directly involved with these courts and these issues here or not. Yeah, these days they should have a codex of videos of each new public service employee's oath or affirmation publicly given during the nearest public meeting from when they are elected or appointed. And actually from this presentation, you'll be able to find quite a few pointed questions that you could definitely pose even after the fact, because all of this has to be retained as records. That's part of their duties too. Yep, indeed. But let's stick with the program here and get back to the presentation. So, Section 13, the local official's authority. Under federal law, federal official's oath may be administered by locally authorized individuals. Interesting there. So the federal official can be administered by a locally authorized individual, his oath. Authority applies within state, district, territory, or possession where oath is administered. Local officials may administer federal oaths when properly authorized. So federal law does recognize and delegates authority to local officials for administering oaths to federal personnel. Now that's interesting. That local officers may administer federal officials' oaths of office. We're on to section 14 here, the judicial notice of authority of officers within jurisdiction. Courts take judicial notice of officers and their powers. So you can have a court judicially noticed that this particular officer and their powers, they could take notice, see the authority of the officers. Okay. So whenever the recognize official authority without requiring proof when officers act within their jurisdiction. Think about that. This is a presumption. Judicial notice of authority of officers within jurisdiction. This is a tricky one, and if you don't rebut this stands. Courts take judicial notice of officers and their powers. It applies to officers within the court's jurisdiction when question of officers' authority to administer oath arises. So think about that too. It's presumed that they have the authority unless there's facts to the contrary. So courts recognize the officer's oath administering authority within their jurisdiction. We're on to section 15, generally, the duty to administer. Administration of oath is a ministerial act. Willful refusal may be an offense. The officer's good faith belief is no defense. So, willful refusal to administer an oath may be an offense. When they willfully refuse to do it, it may. So it's not certain, but it may be an offense. However, if they try to use the good faith belief to say it's not an offense, that's no defense. Just because they believe they were acting in good faith is not an effective defense against the willful refusal. Administrative bodies must administer oaths when the statute directs. So if there's a statute directing an administrative body to administer oaths, they must. This is not a may. Officers have a duty to administer oaths when required by law or when within their authorized capacity. So administering an oath is a ministerial duty and refusal may be unlawful. All right, as we get on to section 16, jump over here to the chat real quick. And St. Frog Dog, good evening, officer. I challenge your administrative jurisdiction. Nice. If you wish to proceed without proving jurisdiction, you will be acting under color of law, and you will be held personally liable. Beautiful statement there. Leave that up there. Everyone needs to take a look at that. That's exactly what I was alluding to. This is where you have to break down their presumptions because they're standing, as you see here. There's court rulings and other things which support their standing presumptions. So unless you challenge them, and unless they bring facts to support them once challenged here, then it will be acting under color of law. And then there could be a question to the authority. You have rights as ministerial actions have to happen, even if the appointed authority doesn't want to perform it, like filling the proper papers. Yes, sir. All right, let's proceed here. Section 16, generally, unequivocal act. Some form remains essential to distinguish oath from bare assertion. So, some form remains essential. What are they? Statutes prescribing forms are not inflexible iron formulas, though. So the statutes cannot prescribe a particular form. There is no required form. Substantial compliance suffices. So substantial. Substance needs to be there. Compliance suffices where essential matters embraced. And for children, sufficient is ceremony and vice's commitment to truth. So this is the unequivocal acts. Some form remains essential to distinguish the oath from a bare assertion, such as the so help me God and those kinds of things. There are some forms, but they are not inflexible iron formulas either, especially if they're prescribed by a statute. They need to be substantial in the compliance, meaning they're the conscientious binding, right, in compliance. That suffices. Where essential matters, the essential matters to what you're promising to, are being embraced. For children, sufficient if the ceremony evinces commitment to truth. Contemporary informality in ceremony does not defeat a valid oath where manifested intent is to be bound is clear. So we learn from section 16 that some formal act is essential, but what's really important, the substantial compliance with the form is sufficient. So we want to make sure the substance is being addressed in whatever form is being done. There has to be some form that will be essential, but what's essential is that the substantial compliance suffices. On to section 17. Jump over here to the chats. Feeling sorry. All right. The presence of authorized official. Declarant must take oath in presence of authorized officer. In presence. The officer must be duly authorized to administer oaths. Again, this is typically presumed if they've been accepted and been acting in that capacity. Personal presence required for valid administration. To make a valid oath, the declarant must personally appear before an officer authorized to administer it. And this is the real word appear, not the legal term, I believe. To make a valid oath, the declarant must personally appear before an officer authorized to administer it. So the oath requires the declarant to be physically present before the authorized officer. No agents here, no proxies. All right, we're on to section 18, the validity of oath by telephone. Oaths cannot be taken over the telephone. Personal preference of officer is required. The officer, affiant, and paper must be physically present. So the personal presence of the officer is required. And long distance swearing is unauthorized and illegal. So no swearing. So what we learn from this, oaths can't be taken over the phone. The personal presence, not preference, I said preference, the personal presence of the officer is required. The officer, affiant, and paper, three things, must be physically present. Long distance swearing is unauthorized and illegal. Personal presence requirement ensures the person actually took the oath, not just for identification purposes. Interesting there. So understanding the intent. Well, this is good enough for the court to be on Zoom. No, for it's not just for identification purposes, the personal presence requirement. That's what we're looking at here. And oaths cannot be taken validly by telephone. The personal presence is required. And we're on to section 19, administration within official's own territorial jurisdiction. Let's jump over here to the chat real quick. You Have Right says the preamble of every state says something along the lines of thankful to Almighty God for these freedoms or something, yes, to that effect. So that it is not a stretch for them to be obligated to swear to God. Exactly. And that's why it's typically been enshrined into the whole effect of oaths and affirmations. But because we do have freedom of religion and it has been challenged, it can't be an ironclad requirement. And let's see here. We got some more here. Where am I? There we go. Swear the oath to God a very serious matter. So help them God. Exactly. And that's the conscientious bind to the oath. Can oaths be taken with video chats? I doubt that. Yeah, and not according to the laws I've seen. I've seen a couple swearing in my day, and they were all handled at public meeting, always. St. Frog Day says, I kind of messed up when I went to court. I refused to swear on the Bible under penalty of perjury. I forced the separation of church and state and swore to my truth under law they had to accept. You kind of messed them up. Yeah, and you don't have to swear on the Bible. That's we're about to get to. Everyone keeps jumping ahead of the program here. Great job, Frog Dog. Yes, indeed. All right. I'm going to try and keep moving fast here so we don't get too ahead of, you guys don't keep getting ahead of the presentation here. Administration within the official's territory jurisdiction. Oath must be administered within territorial jurisdiction by a person duly authorized to administer the particular oath. The presumption officer acted within authorized county. So we came on that in the Notary Public presentation from AmJur, that the presumption that the officer is acting within the authorized county when they're doing it. And it may be taken at any place the officer happens to be. So it's presumed it happened in the authorized county, but it may be taken any place the officer happens to be. Officers are presumed to perform their duty within their authorized jurisdiction, although they can do it at other places, if that makes sense. But the oath must be administered within the officer's legal jurisdiction, but it may be taken at any place the officer happens to be. We're on to strict compliance with formalities generally. There are no particular formalities required for a valid oath. Substantial compliance with prescribed form is often sufficient. As we said before, the substantial compliance, not strict, with a prescribed form. Any form that appeals to conscience and binds to truth is sufficient. As we said here, has to be some form of the appeal to conscience, whether it's swearing to God or an affirmation of something, but it appeals to conscience on the good faith side. There's a penalty for punishment on the other, and that's what binds the statements to truth. A mere assertion without perjury consequence is not sworn statement. The form affects administration, but not sufficiency for perjury purposes, if essential elements are present. So again, the substantial compliance is what really counts, and no rigid ceremony is required. Any form binding conscience and allowing perjury charges suffices. So there it is. And we get to everyone's favorite part here, the touching or kissing of the Bible. Section 21. Touching or kissing the Bible is not essential to taking oath. Physical contact with religious text is not required for validity. Oath validity depends on substance, not ceremonial gestures. Again, we're back to substantial compliance. The legal validity of an oath is independent of physical contact with religious texts or objects. That's worded very nicely. Touching or kissing the Bible is not required. All right. You have rights as frog dog is one being, so I should stop putting a space between, but I am not perfect. I hope you excuse me, frog dog. Even the Bible tells you not to take oaths. Yeah, exactly. So even religious people also may object to taking oaths and opt for the affirmation. Indeed, that's an important distinction to make there. So it's not as if you're being atheist or anti-religion. It could be even more that you're just more deeply into your religion, and that's why you don't swear. And that's probably the best position to have if that is true for you. All right, let's get to holding up the hand. It's not just for when you have to go to the bathroom. Holding up hand is not essential to validity of oath. Statutory provision describing this form is generally directory. Direct mean to direct. So the statutory provision describing the form, holding up a hand, is just to direct. It's general and directory, not required or requisite, I guess. May suffice when express statute makes it usual mode, and it can be valid without "so help you God" recitation. Now, the uplifted hand ceremony is a traditional form, but not a mandatory requirement for a valid oath. Interesting. So raising the hand is generally optional unless a statute mandates it. Again. But then again, that's still directory. All right. And that takes us to section 23, generally, the presumption of proper administration. There is a standing presumption that the oath was properly administered. As I said, unless that's challenged, there's that standing presumption. The officer is presumed authorized to administer the oath, but did you check to make sure he was? The formal defects or omissions do not overcome presumption. If he didn't raise his hand or touch the Bible or kiss the Bible, that does not overcome the presumption. So not formal defects, they need to be substantial. Presumption stands absent contrary proof. So you need proof of the facts that you bring, not just facts or allegations, no conclusory allegations or improbable inferences or unsupported speculations. You need to have proof. Legal system favors validity of oaths that appear regular on their face. There's a prima facie validity to oaths. Again, just because you see it or you see a formal defect does not overcome the presumption that it was properly administered. Oaths are presumed properly administered unless proven otherwise. And we have here, St. Frog Dog says, "I'm not the type of guy I seriously call people Spanky and Frankie, whatever somebody answers to is meaningless as long as they answer." You have rights, cops have too. He says, "The oath is supposed to be given or taken by people who have given up their own sense of self, even their own religion. How is the oath taker going to uphold his own religious values when he is supposed... See here, when he is supposed to be upholding the religious freedoms of the people? He will either serve his own religion or denounce the religion of those he serves, or he'll have to denounce his own religion." Perhaps, I mean, there's that conundrum there, but I'm not too sure that would be a something that would presume that either. And you may not cross your fingers during an oath. I think we've missed that section. That's section 24, but that was omitted. Yeah, it's a tricky one there when it comes down to the swearing. Again, most of this stuff is just formalities, as we saw here, and the holding up the hand, the kissing of the Bible. These are really just archaic formalities that have, they're still lingering today. But what really matters the most is a substantial compliance. So, the particular formalities are not required. And with that takes us to the end of the presentation here. A man who assumes a public trust must assume himself as public property, Thomas Jefferson. Indeed, public service is voluntary servitude. They are voluntary slaves to the people. So their rights are suspended for their benefits and privileges and obligations to serve first. So that's a fiduciary duty of care that's required of all public servants. And the oath is what binds them to it through conscientiousness. And the penalties of perjury is what is there in case they are to violate that. St. Frog Dog says, "Thank you for your informative and your time, insightful, and always enjoy your videos." Well, thank you very much, and I appreciate it. This is why I do it, is to make sure everyone's getting kind of information that I find useful as well, and hopefully you all do too. And with that said, I thank you all for attending this one on the Oath and Affirmation from American Jurisprudence. And You Have Rights says, "You can't be public property and have a self-owned religion? Yeah, well, it depends. Remember, you can operate in different capacities. And if you can separate those and there's no conflict of interest between them and all those duties and obligations can be met without any hindrance because of beliefs, then I don't see any problem with that. Indeed, Bill Thomas, I enjoyed the chat too with all of you, and take care to all of you as well. Salute to you all for being interested in these topics, which really are there to protect the freedoms we do have. And I hope to see you all on the next one. Peace out.